Howdy, I'm Danielle with the Dean Law Firm. Today we're diving into a subject that is not really that exciting, but could make a huge difference in your employment and your business, and that is non-compete agreements. What is a non-compete agreement? Non-compete agreements are exactly that, an agreement between two parties or two entities, usually an employer and an employee, or two businesses that want to joint venture, that prohibit competition during the term of the relationship and for a specified period after the relationship terminates. We often get calls, aren't non-competes invalid in Texas? And that's simply not true. But the law does place restrictions on how far these agreements can go because Texas courts want its individuals and businesses to succeed and not be deprived of a way to earn a living. So what makes a Texas non-compete valid and enforceable? Two things. Number one, it must be ancillary, and number two, it must be reasonable. Let's break those down for you. The first, ancillary. This simply means that it can't be a standalone agreement. It usually goes hand in hand with a confidentiality provision or some other type of agreement more than just an employment agreement. All ancillary means is there must be a give and take. For instance, the employer may disclose confidential business practices, pricing, customer lists, etc. And in turn, they require the employee to be faithful and loyal in maintaining that confidential information and not using it to compete and start their own business or sell it off to competitors. Let me explain using an actual case that we consulted on. A local gym wanted to hire experienced and qualified personal trainers. As part of their employment package, the gym required its personal trainers and employees to sign a confidentiality agreement and a non-compete or non-solicitation agreement. The gym wanted to hire and retain these qualified individuals, but it recognized that it was also giving access to pricing, program materials, branding, marketing, and most importantly, clientele. Obviously, the personal trainers wanted employment, but the gym needed to protect itself from the personal trainers going out on their own and basically taking the clients from the gym. The next step in determining whether or not a non-compete or non-solicitation agreement is valid in Texas is the factor of reasonableness. Now, this is probably the most frustrating for individuals or businesses to hear because it is a very gray area of the law. But the courts have given us some guidance on what is to be considered reasonable. Think of them as ingredients in baking a cake named reasonableness. The first is time. In other words, how long does the restriction last? Does it last for 6 months after the agreement terminates? Or does it last for 6 years? And again, this is a case-by-case basis and analysis. So what's reasonable for 6 months in one scenario may not be reasonable in another scenario. The second ingredient in our reasonableness recipe is geography, and that is how far distance-wise does the restriction go. It could be 5 miles or 50 miles, or even a whole state or a whole region. Whether or not that restriction is reasonable, again, depends on this case facts. What is reasonable for our local gym in Houston, Texas, maybe 5 or 15, 25, even 30 or 45 miles. that restriction in rural Texas may not work because the gym would basically be putting that personal trainer out of business if the nearest town is over an hour away. So this is a fact-intensive review of whether or not the geography restriction is reasonable. The third recipe ingredient is scope. And again, this is a little convoluted, but I'll try to break it down for you. This is how much activity, how much of the employee's job is going to be restricted in the future. Think about it this way. If a personal trainer trains at the local gym, but then decides to move or to start their own gym, what kind of activities are going to be prohibited? They may not be prohibited from owning another gym as long as they don't use the material that they gained from the local gym, but they may be prohibited from training other clients. And so, again, this is very fact specific, and it needs to be narrowly tailored to what the employee or other entity learned and can use to compete. Because these are so subjective, Texas courts will evaluate each matter on a case-by-case basis, looking in depth at the specific facts. So how can the Dean Law Firm help you in this scenario? We get calls all the time asking whether or not a specific non-compete agreement is valid or enforceable, or even to draft a non-compete agreement for a business or an entity. And we can certainly help with all of that. If you're looking for just an evaluation on whether or not an agreement is enforceable, whether you're trying to enforce the agreement or trying to make sure that the agreement is not enforceable, we can provide a flat fee review and consultation on that matter. Similarly, we can help you draft an enforceable and valid non-compete agreement for your business or entity. Simply give us a call, subscribe below for future updates, and let us know how we can help.